So the next item is Stage 3 proceedings on the Children Equal Protection from Assault Scotland Bill. In dealing with point of order, Adam Tompkins.
Thank you, Presiding Officer. I sought to lodge 2 amendments to this bill, Presiding Officer, but both were ruled inadmissible. This bill is about the criminal law of assault, and my amendments would have clarified the meaning and scope of the law of assault for the purposes of this bill. Moreover, they would have done so in a manner designed to give effect to, and not to frustrate, the stated policy objectives of those who have promoted and supported this bill. And those objectives are, of course, to bring to an end the physical punishment of children. The problem is that this badly drafted bill doesn't stop there. It goes much further, because in Scots law, an assault can be committed even if no physical force is used. So given that my amendments were in line with the stated policy objectives of the bill, and given that they were avowedly concerned with the scope of the law of assault, which is the subject matter of this bill, can I ask why were they ruled inadmissible?
Can I thank Mr Tompkins for giving me advance notice that he intended to raise this as a point of order. As the member may be aware, the criteria for admissibility are laid out in standing orders. At stage 2, these decisions are a matter for the convener. At stage 3, they're a matter for me as presiding officer. The key aspect here of admissibility is that an amendment must be consistent with the general principles of a bill and it must be relevant to that bill. Selection of amendments is a matter for me at stage 3, and I take a number of factors into consideration when reaching my decisions. So, point of order, Mr Tompkins.
I'm grateful, Presiding Officer. Presiding Officer, I cast absolutely no aspersions on the motives or purposes of those who advised you about this matter. I have no doubt that they acted in good faith throughout. But I do have concerns about the effect of their advice and your ruling on this. As I understand it, Presiding Officer, although please correct me if I'm wrong, members of this Parliament have no means of challenging the advice of officials where, as here, we perceive that that advice is so narrow to rule out amendments to legislation honestly believed to be directly and rationally connected to it. So can I ask you this? Are you content that our rules are appropriate in this regard, and do you think that they need to be reviewed?
Thank you, Mr Tompkins, for the point, and I am content. The rules are there to make sure that matters for policy discussion, which the member has now raised and put on the record, these are matters for the policymakers, which is all of us here as MSPs, and they're not matters for debate between the Chair and members. The Chair has to treat everybody in a fair manner and apply the rules fairly across the board. I would also point out in this case that I think the legislation team did try to work with the member as much as possible to find a way to express those in terms of amendments. But the member has had an opportunity at least to make his point on the record. On that note, can we move on to stage 3 proceedings? And could I ask that members have with them the bill, that is the bill, SP Bill 38, the marshalled list and the grouping of amendments. I will just remind members that the division bell will sound and proceedings will be suspended for 5 minutes for the first division of the afternoon, and there will be a 30-second vote at that stage. Thereafter, there will be a 1-minute pause for the first division after a debate. Members who wish to speak in any debate on any group of amendments, I should say, should press the request to speak button as soon as I call the group. So we turn now to the marshalled list of amendments. And Group 1 is on the effect of Section 1 on parental responsibilities. Can I call Amendment 2 in the name of Oliver Mundell, grouped with Amendment 3, Oliver Mundell to move Amendment 2 and to speak to both amendments in the group?
Thank you, Presiding Officer. I move Amendment 2 in my name. Both Amendment 2 and 3 are designed to be simple amendments for the avoidance of doubt. That means they do not add anything new to the bill, but simply seek to clarify what's already on the face of it. They were intended within the narrow scope of the bill to try and provide some reassurance to parents and address some of the concerns the committee heard during its deliberations of the bill. They're made in good faith by myself, as I wish to allow the courts, when considering cases that come forward under this legislation, to look at the best interests of the child. I'm confident that when they do so, that will remove some doubt, particularly around issues of restraint and some other similar circumstances, which can be very complicated in practice to deliberate on, because often there's a fine line between what could appear like physical punishment to some, but might well be appropriate in very limited circumstances when exercised properly by caring parents who are acting within the law. I also draw out the distinction of restraint specifically and see of Amendment 2 makes specific reference to the exercise of a parent's lawful rights and responsibilities. And this is designed to capture those duties and responsibilities that are placed on parents already by legislation, namely in the 1995 Act. I don't intend to say a great deal more, given the fact these have already been debated at stage 2. I move both amendments in my name.
Thank you very much. I call Alex Cole-Hamilton.
Thank you, Presiding Officer. I rise in opposition to these amendments. I cannot support them for a number of reasons. Firstly, Amendment 2 suggests in part, if through interpretation, that there may be times when assault is justified if it's in that child's best interests. We aren't creating a new offence in this bill. We are amending... I will.
Oliver Mundell.
I just want to clarify for Mr Hamilton, what I'm referring to is circumstances that exist in Scots law at the moment where an assault could be someone raising their voice, putting someone in a state of fear or alarm. I would think both of those things can be acceptable for parents to rightfully do under the law, and I want to make clear that that's not what we're getting at in this bill.
Alex Cole-Hamilton.
And again, we will cover this when we talk about judgment and indeed the application of these policies by the judiciary. As I said, we aren't creating a new law. We are repealing an ancient defence. And it's a legal defence we've repealed before. Nowhere in statute or in common law have we felt the need to clarify that physical intervention or restraint of a hysterical and drowning man is not assault. It's just common sense. And as such, the application of this law will be met by the same test. Every day, our police make educated judgments about both child protection and criminal assault. We should not presume to tell them how to do that or where the thresholds for it lie. So we oppose Amendment 2. Amendment 3 further... I will.
I wonder if Mr Hamilton would accept that in relation to the common law, there's already significant case law in relation to assault, and that's often informs how the police decide to judge things. In this case, there won't be.
Alex Cole-Hamilton.
And I'm quite certain the judiciary will draw on that case law to that end. Amendment 3 further muddies the water as well. There is no lawful right to physically chastise, only a defence. It also suggests that there may be other kinds of justifiable assault beyond physical punishment. I'm not entirely sure what these may be, but again, it leaves the Act open into interpretation where we should, for once and for all, repeal this arcane and antiquated legal defence. We will not be supporting these amendments.
Thank you. And Gail Ross.
Thank you, Presiding Officer. And can I take this chance to thank everyone involved in this campaign, which has lasted a number of years, but especially John Finney and his team for steering this bill through. From day one of taking evidence on this bill, the Equalities and Human Rights Committee were told time and time again by organisations and individuals such as the Law Society of Scotland and the Lord Advocate that removing the defence of justifiable assault would improve the clarity in the legal process. This amendment did come forward at stage 2, and after lengthy discussion, Oliver Mundell told the committee he would look at the wording of the amendment, and he has done so by removing the lines to do with maintaining child safety and well-being and to prevent the child from committing a criminal offence. Now, Presiding Officer, whilst I acknowledge that a change has been made, it does little to change the intention of the amendment. Children's charities, most of whom are in the gallery today, and other organisations in Scotland, Bernardo's, Children First, the NSPCC, have urged members not to back this, stating that it would make the law relating to assault of a child unclear, the complete opposite of what the bill intends to do. And if this amendment was passed, it would essentially take away the central intent of the bill and essentially keep a right for parents to use what has been stated before as reasonable chastisement or a loving smack. Now, we talk about clarity, Presiding Officer, so let me be clear here. It is never in the best interests of a child to be hit, whether it's a light tap, a smack, or anything else. And we've heard examples like, well, what if a child runs into the road? Or what if they're about to pull down a pan of boiling water, touch a fire, or an open socket? But the method of teaching children through fear belongs in the dustbin of history when we didn't fully understand the consequences to that child. Now, the other issue with this amendment is when you begin anything with the phrase "for the avoidance of doubt," as the Children's Commissioner states, you create the impression that doubt exists, and it doesn't, or at least it shouldn't. The UN Committee on the Rights of the Child has stated that Scotland should prohibit as a priority all corporal punishment in the family, including through the repeal of all legal defences. So I won't be supporting Amendment 2 or 3 as the... Indeed.
Oliver Mundell.
I understand the line of argument that the member's progressing, but does she not recognise that the bill doesn't do all of those things?
Gail Ross.
Well, I have listened to all the evidence in the committee and I have read everything that we have had in from all the organisations, and I'm sorry, but I have to disagree with you. It will take away the clarity sought, and it will not result in the societal shift that we are aiming for through the bill. Presiding Officer, I told my 9-year-old son this morning that we were doing this today over Skype, and his response was, "I am proud of you, Mum, but I thought it was already against the law to hit people." The young people of Scotland are watching us here today, and I will be immensely proud to vote to align children's rights with adults at decision time by voting for this welcome and much-needed bill.
Minister Marito.
Presiding Officer, I am grateful to the committee for its careful scrutiny of this bill and for taking evidence from a wide range of stakeholders, both those for and against the removal of the defence. I'll discuss Amendments 2 and 3 separately as they raise different issues. The Scottish Government cannot support Amendment 2. Firstly, this purports to establish that the removal of the defence won't affect the ability of a parent or carer to act in the best interests of the child. Who is to decide whether the actions of a parent or carers are in the child's best interests?
Oliver Mundell.
I would have said it was for the courts or police or prosecutors to decide what was in the best interest of the child with the purpose of the offence, which is the same as how the whole bill is drafted.
Minister.
So I would argue that the amendment isn't clear whether it's the parents or the courts who are to decide. What if a parent or carer decides that physically punishing the child is in the child's best interests? This is fundamentally at odds with the purpose of this bill, already agreed by the Parliament at stage one moment, which is the purpose of this bill is to give children equal protection from assault with zero qualifications. I'll take your intervention.
Oliver Mundell.
I thank the Minister for giving way. I think that this bill fails to recognise the distinctions that already exist between children and adults in many aspects of the law. And I would say that it is appropriate for parents to make a judgment of what's in the best interests of their child. That should be the first thing that happens. And where they take that decision and it's incorrect, that's when I think police and prosecutors should set in, and I think this makes that principle very clear.
Minister.
The Scottish Government believes that parents should not be allowed to assault their children. It seems that the member is of a different view. The amendment purports to establish that the removal of the defence won't affect the ability of a parent or carer to restrain a child, either to keep them safe or to prevent them from coming to harm. The removal of... Certainly.
Liz Smith.
What circumstances, Minister, is a parent allowed to assault their child under current law?
Minister.
There is a defence there of reasonable chastisement. We plan to remove that. That is used on the occasions when a parent assaults their child. That defence can currently be used. We intend to remove that today. The removal of the defence does not impact on the ability of a parent to use restraint to prevent their child from coming to harm. At its heart, restraint is an act of protection. Physical punishment is an act of discipline. They are fundamentally different, certainly.
Under the legislation as drafted, who will decide what the difference is between restraint and physical punishment? Who will make that judgment?
Minister.
So, As is the case for any report of assault, the police will investigate it and the Crown Office and Procurator Fiscal Service will make a decision. But they did note in their written evidence on this bill that the use of physical force to remove a child from danger, such as pushing the child out of the way of an oncoming car, would lack criminal intent and would not, for that reason, constitute an assault. I think I'd like to make some progress. We do not agree that physical punishment is required to protect children from harm. We conclude that the bill as drafted will not change a parent's or carer's ability to restrain a child to keep him or her from harm. In line with this, we consider the element of the amendment to be unnecessary. Certainly.
Joanne Lamond.
It says that across the chamber, people are committed to children being equally safe. But our children are not equally safe under the current law. And therefore, I was astonished to see that in the financial memorandum, it says this bill, it's not anticipated this bill would incur significant costs to implement. Can I ask a commitment from the Minister that there's a proper understanding of how vulnerable some of our children are, and despite their parents actually breaking the law as it currently stands, are left in homes neglected and not nurtured? That supporting these children cannot be done without adequate resource. So can I get a commitment from the Minister, regardless of what this individual bit of legislation says, if the intent of the bill is to keep our children safe, what resources will go into our communities in order that happens for all of our children?
That's an important point, although it's not specifically to the amendment. I'll allow the Minister to respond.
I can absolutely assure everyone in this chamber and all the people in Scotland that the safety, security and well-being of the children of Scotland is paramount for this government.
Cole Hamilton.
I'm very grateful. Does the Minister recognise, as I do, that in Ireland, where Gillian Van Turnhout, former Irish Senator, who is in the gallery today, brought this legislation through the Dáil, that at that point there was no financial memorandum because it was an amendment to another bill. It passed unanimously in the Dáil. It has led to children being protected and is not mutually exclusive from a government initiative to drive up positive parenting in our country.
Minister.
For once, I agree with Mr Cole Hamilton.
Breakout of consensus. What a loving.
Finally, the amendment purports to provide that the removal of the defence will not stop a parent from exercising their parental responsibilities and rights. Section 1 and 2 of the Children's Scotland Act 1995 clearly set out what these responsibilities and rights are, including the responsibility to safeguard and promote the child's health, development and welfare, and the right to control, direct or guide appropriately the child's upbringing. This strand of the amendment seems to be an attempt to create an exception to the removal of the defence, so that a parent could say that they physically punished their child because they did so in exercise of their right to control the child's upbringing. Fundamentally, again, this is at odds with what Parliament has already agreed to provide children with equal protection from assault. This would muddy the waters. We have frequently heard throughout this bill's progress through Parliament that it will bring clarity to the law. This amendment would take that welcome clarity away, again leaving parents unclear about the law. Parental responsibilities relate to a child's health and well-being. The evidence is clear that physical punishment can have long-term negative outcomes on a child. Retaining the ability to physically punish children, or even just creating doubt about whether this is permissible, is at odds with the evidence. Turning to Amendment 3, the Scottish Government does not support this amendment. Section 1(1) of the bill is clear. It abolishes the rule of law that the physical punishment of a child in the exercise of a parental right or right derived from having charge or care of a child is justifiable and is therefore not an assault. This does not affect other parental responsibilities and rights as set out in the Children's Scotland Act 95. The member has said, and we agree, that the offence of assault is wide. However, We are also mindful that, as the Lord Advocate said when he gave oral evidence, the law of assault is applied day and daily by police officers and prosecutors. The law on assault is clear and is regularly used. There is no need for an amendment that seeks to avoid doubt where there is none to begin with. Section 1.1 is clear. It is about physical punishment, as that is what the defence of reasonable chastisement is about. So the amendment would clarify nothing. The parental responsibilities and rights in the 1995 Act are not otherwise affected by this bill. What this amendment would do is add doubt, not clarity. Questions might... Certainly.
Tompkins.
I'm very grateful to the Minister for being patient with the number of interventions she's given. Thank you to her. I agree with what the Minister has said about clarity in the criminal law. I agree with what Gail Ross said earlier in this debate about the fundamental importance of clarity in the criminal law. The policy objectives of this bill, as stated in the policy memorandum attached to it, are, in paragraph 4, and I quote, "The aim of the Children Equal Protection from Assault Scotland Bill is to help bring an end to the physical punishment of children," unquote. The Stage 1 report of the committee says, again, paragraph 4, the bill's purpose is to discourage the use of physical punishment. Not my words, but the words of the committee and of the policy memorandum. And the amendment that we're talking about, Amendment 3, in the name of my colleague Oliver Mundell, says, for the avoidance of doubt, this section applies only with regard to physical punishment. How is that stirring up, how is that muddying the waters? How is that doing anything other than bringing welcome clarity to an element of this bill which is at the moment anything but clear?
Minister.
We want equal protection for children and adults, and the bill achieves this by removing the reasonable chastisement defence. We think this is the right outcome. Is the member suggesting that parents should have the right to raise a hand to their child so that the child thinks that there is physical injury imminent? An adult doing that to a member of the public could, depending on the exact facts and circumstances, be committing assault. I can see no good reason why it would be acceptable for a parent to do that to their child. No child should fear physical injury at the hands of a parent, certainly.
Oliver Mundell.
And that's exactly what my amendment seeks to do, because it's about physical punishment. I think there's a number of actions a parent could take that wouldn't be appropriate for me to do to another adult, confiscating a mobile phone, restricting their access to finance, refusing to let them out of the house, and in some cases, lifting a person up and physically removing them from one setting into another. All of those things could be considered to be a form of assault or abuse when conducted between one adult and another, but wouldn't be inappropriate for a parent.
Minister.
I disagree profoundly. I think that what this bill does is bring simplicity and clarity to a situation which is currently confused. And it appears that the Law Society of Scotland also agree with that view. As the current law stands, certainly.
Johnson.
Just in the interest of clarity, can the Minister tell us whether or not she thinks it's acceptable to lift an adult and place them in another room, and whether she thinks it's unacceptable to do that to a child? I think it's an important clarification that Oliver Mundell requested.
Minister.
I'm not going to give. I don't listen to each other. So honestly, you're going
So
you're coming up with stupid.
I think I am going to just ignore that point and move on. I think the law of assault is crystal clear. I think the law of assault is prosecuted day in, day out, perfectly clearly in Scotland. I have no concerns about the current law of assault. What the Law Society of Scotland say is that as the current law stands, there is a lack of clarity for the public about what parents and others can and cannot do by way of physical punishment of children. This has led to confusion amongst parents and carers. They support the bill because they think it will provide much needed clarity. We have heard repeatedly throughout the progress of this bill that it will bring clarity to the law. I cannot welcome an amendment that would lead to confusion. We do not want the effect of this bill to be that parents continue to have doubt on what is and what is not acceptable. I urge members to reject these amendments.
And the call on John Finney.
Thank you very much indeed, Presiding Officer. As with those Stage 2 amendments, I don't accept that there's any doubt to address the provisions liable to do more harm than good. Adding in additional material could cause difficulties in interpretation and hamper the ability of the relevant authorities from exercising appropriate judgment. Judgment that others say is applied on a daily basis. And we heard very clearly, as did Mr Mundell, present at the committee, to hear the Lord Advocate, the police and social work all say that this simple proposal brings much needed clarity. It's hard to see how you could apply the additional tests set out in the amendment in a consistent manner, given how vague and subjective there are. There was a deliberate policy choice not to include specific statutory provision on circumstances in which force, rather than physical punishment against a child, would be permissible. Although consideration was given to the inclusion of such a provision, the view was taken that the better approach would be for the common law of assault to apply, as it would in relation to adults, of course.
Oliver Mundell.
I understand the point the member is making and that it was a deliberate decision, but does he accept that there are other people who take a different view, and not just those who oppose the bill, like myself, but Professor Andrew Tickell, who set out in detail in the National, in a column, why he felt it would have been better to create a specific offence with clearly set out thresholds so parents knew when the law applied.
John Finney.
Well, an interesting choice. I have to say I would defer to the Lord Advocate in matters of law in general. There's risk inherent in this clarifactory approach that seems to be attempted in Amendment 2. By setting out matters in statute in this way, there's a risk of loopholes being created, of dubiety as to the reach of any matter listed in statute in this way. And the most important factor that a number of, and would indeed address my colleague Daniel Johnson's position, under the common law of assault, criminal intent is an essential element of the offence. You know, and lifting a child from one room to another was certainly, to my mind, wouldn't fall into that. The use of force to avoid accident or injury, as others have said, indeed of an adult, would not ordinarily amount to assault, provided excessive force wasn't used. In any case, the key point is that none of these actions would constitute punishment, and it is only the law relating to the physical punishment of a child that is changed by the bill. Evidence at stage 1 and 2 from the Lord Advocate, the Crown Office Procurator, Fiscal Safety, the Law Society of Scotland, Police and Social Work all stated that the bill, as drafted, would simplify the legal position. The amendment is likely to have the reverse effect of that intended. That is, it will introduce doubt rather than dispel doubt. In terms of A, this would change the purpose of the bill, as a parent could consider physical punishment to be in the child's best interest. It would also introduce confusion and subjectivity, as there is no objective test of what is in the child's best interest. The committee heard that prosecutors will continue to consider the best interest of a child as part of the public interest test, and that the relevant matters are already included in the prosecution code as matters that would be taken into account when investigating and prosecuting any case of assault. Of course.
Oliver Mundell.
If the member accepts that the best interests of the child are already considered as part of the public interest test, why does he have such a strong objection to having that test on the face of the bill?
John Finney.
Well, I've already explained to the member that Lord Advocate said that the simplicity of this bill, well, it is the answer, Mr Mundell. You might not like the answer, but it is indeed the answer. It's the simplicity that's the attraction. In any case, what you're seeking as regards the child's interest is an intrinsic part of Scots law, and indeed the way that all our public bodies discharge their obligations. In terms of 2, the amendment's unnecessary. Restraining a child to protect it from harm is something quite distinct from physical punishment. There's no overlap, so there should be no doubt about the implications for restraint at all. The issues of permissible physical restraint of children, apparently in connection with their safety and preventing harm, is not the focus of the bill, which is dealing with the use of force against a child in punishment. The bill only legislates in relation to physical punishment, so has no implications for situations that don't involve punishment, e.g. where physical hurt is caused to a child in order to protect them from greater immediate harm. In terms of C, it begs the question, by protecting only the exercise of lawful, quote, parental rights and responsibilities. Under the current law, smacking a child can count as such as a lawful exercise. The point of the bill is to change that so that smacking a child as punishment can never be lawful. So as soon as the bill becomes law, and I hope it does, paragraph C no longer has any application and so becomes unnecessary by virtue of its own wording. So, turning to Amendment 3, as with Amendment 2, I don't accept there's any doubt. It's clear from the bill that it only changes the law in relation to physical punishment and not more generally. So there is no need for this amendment. The amendment would therefore likely create uncertainty, doubt and confusion rather than remove. Yes, indeed.
Oliver Mundell.
I thank the member. He's been very, very generous and patient. Can I ask, in terms of the rule of law that's referred to in Section 1, does it only apply to physical punishment?
John Finney.
Can I ask the member whether he can clarify whether the rule of law that's mentioned in Section 1 only applies to physical punishment?
John Finney.
The rule of law applies all the time. You've heard from the Lord Advocate.
Oliver Mundell.
I meant the specific rule of law around reasonable chastisement and justifiable assault. Do they only apply to physical actions at present in Scots law?
John Finney.
Mr Mundell knows what the definition of assault is. He knows that the discretion... Well, that's the answer you're getting, Mr Mundell. Again, you might not like it, but that's the answer you're getting. The practitioners have all said the bill brings welcome clarity, and I would ask members to not support either amendment and have in their mind at all times the word clarity, the clarity that the practitioners in the legal profession believes this delivers. No.
Can I ask Oliver Mundell to wind up and to press or withdraw his amendment?
Thank you, Presiding Officer. I think we've had a fairly robust debate within the section, so I won't take up too much time. There are only a few points I'd quickly like to make, and that is that if we're going to focus on things being decided on the basis of intent after investigation, then sadly that means that families will already have been taken to court, been in contact with our criminal justice system before we get to a definitive answer on that question. Yes, certainly.
Alice Cole-Hamilton.
I'm grateful to the member for giving way, but that is a rather categorical statement that families will be subjected to the full force of the law before whether or not they committed criminal intent is determined by a judge. These decisions are taken on a daily basis by attending police officers. It's absolute fallacy to suggest that we're going to have legions of parents march through the courts to test this legislation.
Oliver Mundell.
I understand the point the member is trying to make, but I'm afraid the way this legislation is drafted, he's not able to make that statement with any certainty whatsoever, because I think, as most members would, I would expect legislation passed by this Parliament will be enacted by certainly.
Mike Rumbles. Sorry, Mike Rumbles. Is your card in?
Oh, sorry. I beg your pardon. I thank the member. Thank the member for taking my intervention. I hadn't intended to intervene earlier on, but I have to say that on listening to this debate on these amendments, it's quite clear to me that the member objects to the bill, and all his amendments are doing are muddying the waters in the bill. Would it not be more honourable? Would it not be more honourable to withdraw the amendments before we get to a vote and make your objections to the bill?
Oliver Mundell.
I thank the member for his intervention. I don't accept that. And I certainly speak on behalf of more than just myself on these benches, because there are members of my party who would have liked to vote for a bill this evening. Not all of us, but there are some. And as an opposition member in this Parliament, I regularly vote against legislation at stage 3, but vote for amendments and bring forward amendments to try and improve legislation. I want the legislation to be as good as possible because it embarrasses this whole Parliament when substandard legislation is passed and we later see challenges to that legislation in court. And I am concerned that because of the lack of adequate thresholds, as I'll cover in my stage 3 speech, that this will end up being the subject of question in the future. And I think we should make clear that restraint is something that is different, in our view, than physical punishment, because often, when looking at assault, things that look one way to a bystander can be quite different in the circumstances. And I don't think it's proportionate or appropriate to wait until further down the line, once things are already going through the criminal justice system, to then decide whether or not an intent existed. I think it's better to make those considerations up front, and that's what the amendment's about. Thank you, Presiding Officer.
Thank you, Mr Mundell. So the question is that Amendment 2 be agreed to. Are we all agreed? We're not agreed. I'm going to suspend Parliament for 5 minutes to summon members. There may not be many members who are not here, but I'll give them a chance. So suspension for 5 minutes to summon members to the chamber for the vote. Thank you, colleagues. That's our suspension over. So if members could take their seats for the vote. The question is that Amendment 2 be agreed to. Are we all agreed? We're not agreed. Members may cast their votes now on Amendment 2. The result of the vote on Amendment 2 in the name of Oliver Mundell is yes 47, no 64. There were no abstentions. The amendment is therefore not agreed. Can I call Amendment 3 in the name of Oliver Mundell, already debated? Oliver Mundell to move or not move?
Move.
That is moved. The question is that Amendment 3 be agreed to. Are we all agreed? Yes. We're not agreed. We move to a division. Members may vote now. The result of the vote on Amendment 3 in the name of Oliver Mundell is yes 47, no 63. There were no abstentions. The amendment is therefore not agreed. We're going to turn now to the second group, which is prosecutorial guidance on the Act. Can I call Amendment 1 in the name of Richard Lyle in a group of its own, and Richard Lyle to move and speak to Amendment 1.
Thank you, Presiding Officer. I rise to speak to Amendment 1, my name, which has attracted the support of colleagues across the Chamber. Cross-party support for this amendment, I think, is a reflection of legitimate concerns shared by colleagues on all sides. Frankly, I share those concerns. Members will recall my rather forthright comments last time this legislation was discussed, and I must admit I am concerned. I'm the father of 2, the grandfather of 3, shouldn't be 4. I love them all to bits. However, I am aware that this bill has the backing of many colleagues, and I accept the law is going to be changed in this regard at decision time. I accept, in bringing forward this amendment, I simply want to ensure that the operation of the law continues to be proportionate in terms of its impact on families and children. Amendment 1 is very simple indeed. Established before the legislation comes into effect, the Lord Advocate must publish clear guidance for the courts and the police to help them navigate the new legal landscape and continue to deal with parents sensibly. I think that guidance should do 3 things. First, it should set out very clearly what a proportionate and appropriate response to the individual circumstances of a particular case. Secondly, it should outline the circumstances in which alternatives to prosecution should be considered. And third, it should outline appropriate pathways that should be considered as an alternative to prosecution. I don't think it's in anyone's interest for people to be treated harshly under the law. I think that in many, if not most cases criminalisation would be a step too far. The effects of a police investigation, court appearances, prosecutions and families in these scenarios would be hugely disproportionate, especially for children involved. Criminalisation should be reserved for adults who have acted to harm a child, not for parents who are simply ill-informed. Good guidance by the Lord Advocate will avoid the scenario which has often been talked about, where a parent who taps a child in the hand or a backside ends up with a criminal record. Tap in the hand will not be prosecuted under current law and reasonable chastisement under Section 51 of the Criminal Justice Scotland Act. However, removing the defence will create ambiguity in the law, which will lead to disparity in enforcement. In evidence to the Equalities Committee, Michael Sheridan of the Scottish Law Society said, under the proposed legislation, A parent could be guilty of an assault, even if acting reasonably. And the Lord Advocate himself has said that the impact of the proposed legislation in terms of prosecution is still unknown. The guidance outlined by Amendment 1 would clear up any uncertainty and allay the public's fears. Amendment 1 reflects the approach being taken by the Welsh Government, which is also wants to remove reasonable chastisement from the law in Wales. Deputy Minister Julie Morgan has said that the Welsh Government favours out-of-court disposals for parents who use mild physical discipline following a change in the law in Wales. The Welsh Government aims to establish a bespoke diversion scheme which prevents parents being landed with a criminal record, and the Welsh Assembly Children's Committee has called for a clear pathway to divert cases that would currently be captured under the defence of reasonable punishment away from the criminal justice system where appropriate and proportionate to do so. The Welsh Committee states that such a scheme would focus on encouraging and supporting parents rather than penalising them. I quite agree. It seems to me that the Welsh Government's approach is sensible. It's one that we should mirror here in Scotland in the interests of parents. Presiding Officer, there are strong feelings on both sides in this debate, and I've witnessed it in the last 20-30 minutes. But despite this, I don't think there is common ground between MSPs today, regardless of our individual. Despite this, I do think there is common ground between MSPs today, regardless of our individual views or party affiliation. I do not believe that any of us would like to see ordinary loving mums and dads criminalised. I don't. By supporting Amendment 1, you'll be putting a guarantee in the face of the bill that sensible and proportionate guidance will be produced ahead of a change in the law. Let's reassure parents that they will not face draconian punishments under a so-called smacking ban. Let's show them that we as politicians want to support them in bringing up their children. Thank you. I press Amendment 1.
Thank you, Mr Lyle. And before calling the next speaker, we're just at the agreed time limit, so I'm going to exercise my power under Rule 9.8.4a to allow this debate to continue beyond the limit in order to avoid the discussion being unreasonably curtailed. So can I call Alex Cole-Hamilton to be followed by Oliver Mundell?
Thank you very much, Presiding Officer. The Liberal Democrats do not support this amendment, quite simply because it's unnecessary. In the 54 countries globally that have gone before us in terms of embracing equal protection for their children, they have not seen legions of parents criminalised or marched through the courts. In fact, in New Zealand, we only heard of 8 prosecutions, 4 of which would have been prosecuted anyway since they changed their law. Lord Advocate's guidance is only usually ever sought in special and untested circumstances. A good example of this would be the Lord Advocate's guidance not to prosecute victims of human trafficking who've been coerced into criminality, into committing a criminal act by virtue of their status having been human trafficked. But we are asking the Lord Advocate to guide judges on a range of measures and tests that they already apply every single day. I will.
Oliver Mundell.
I wonder, from the point he's making, whether he recognises that the Lord Advocate's already said that he will produce guidance in relation to this bill and recognises some of the concerns that exist.
Alex Cole-Hamilton.
Absolutely, and operationally he absolutely has every right to do that, but we do not require it, therefore, to be on the face of the bill as is proposed by Amendment 1. We have very recent cause to trust the judgment of our Scottish judiciary. Judgment is also exercised by first the police and then the judiciary in a very human way every single day, ascertaining the intent of, from the point of the index incident. And that often leads to an understanding of the circumstances around the alleged offence and a decision not to prosecute. This comes down to the very nexus of this bill. The hyperbole that surrounds the arguments against repealing the defence stem from the fact that they believe that we will have thousands upon thousands of normal, loving parents march through the courts. The international evidence just does simply not stand that up. And for that reason, Presiding Officer, the Liberal Democrats cannot support it.
Well, Oliver Mundell to be followed by Gil Ross.
Thank you, Presiding Officer. I'm always concerned when people refer to laws in other countries without recognising that quite often those countries can have substantially different legal systems with different prosecution policy. And I think it is, given that the Lord Advocate has come to this Parliament and said that he will set out guidance in this case, I think it is perfectly appropriate for MSPs to set out what we feel that guidance ought to cover in order to make this law reasonably foreseeable for parents, to allow them the opportunity to properly understand the types of behaviour that we are seeking to criminalise, rather than leaving that to be interpreted, particularly where no case law currently exists. I think much of what Richard Lyle has said is very sensible. I wouldn't always agree with him on everything, but in this case, I think it was a very measured explanation behind this amendment. And if this was passed, I think it would go a long way to addressing the doubts of parents. It's all very well to say that we have confidence in the prosecutorial procedures in this country, but this will help parents have confidence in the legislation that we are passing. And that's our responsibility, to make sure that people in this country understand what the law of the land is and what our intentions are. Thank you.
Thank you. I call Gail Ross.
Thank you, Presiding Officer. We've already discussed this at length in the committee, and I think that we need to be really careful of the language that we're using here. It's not a smacking ban, it's the removal of a defence, and we need to be careful that we say that time and time again. It was mentioned about the Law Society in their brief that they gave us for this debate today. They say, as the law currently stands, there is a lack of clarity for the public about what parents and others can and cannot do by the way of physical punishment of children. This has led to confusion amongst parents and carers. We support the aim of the bill to provide much needed clarity, and I don't think that they could make that any clearer. The difficulty with this amendment is that, well, sorry, I think you've had enough today. This amendment would infringe the Lord Advocate's constitutional independence. We've discussed this at length at the committee. He's committed to producing guidance, and this is unnecessary, so therefore I will not be supporting this amendment.
Thank you. And can I call Pauline McNeill?
Thank you, Presiding Officer. I just wanted to make a short contribution in favour of this amendment, which I think there was a carefully considered speech given by the member. I'm going to vote for this bill tonight, but I have always had some reservations about not giving a message to parents, as Dick Lyle has said, who doing what they think is best for their children, removing that defence, which is what we will do in law, but not criminalising those parents unnecessarily. Now, I think we need to be clear that in the amendment it says Lord Advocate's guidance for prosecution. To Alec Cole-Hamilton, it's got nothing to do with judges. It's for the prosecution's guidance. And I think it's important to make that distinction. Judges, once the case comes before them, will make a determination on what they think the law is. So what we're talking about here is guidance for the prosecution. I do accept Alec Cole-Hamilton's point, though, that there are few occasions where you'd want to do it. In this case, I think what the Parliament wants to do in this bill is they want to send out a clear message to parents. This is the way in which I think the country wants to be progressive and give that message out. But I don't think in the process we want parents who are actually doing a good job looking after their children. What harm would it do to put this into the legislation? At the end of the day, we can pass something which there's a bigger consensus on.
Thank you. And I call the Minister, Marie Todd.
Presiding Officer, I'm concerned about the implications of Amendment 1 for the Lord Advocate's independence. It is for the Lord Advocate to determine prosecutorial policy, to decide what guidance and guidelines he should issue to the police, and to determine what should be published. This amendment would require the Lord Advocate to produce and to publish guidance. The Lord Advocate gave oral evidence to committee on the 6th of June this year. The Lord Advocate said then that if the bill is passed, he intends to issue Lord Advocate's guidelines to the Chief Constable of Police Scotland on the investigation and reporting of allegation of assaults by parents on children. The Lord Advocate added that those guidelines and prosecutorial policy will support a proportionate and appropriate response to the individual circumstances of particular cases. When appropriate, that response may include the use of informal response by the police, recorded police warnings, diversion, and other alternatives to prosecution. The Lord Advocate also said that the approach to prosecutions will be informed by the state's responsibility to protect children from harm and by consideration of the best interests of the child. So the member can be reassured that work is already in hand on guidelines to the police and on prosecutorial policy. It would not, though, be appropriate to place statutory obligations on the Lord Advocate, who acts entirely independently of government in these areas in relation to the production of prosecutorial guidance and guidelines.
Vermindale.
I'd just be interested in further clarity on why the Minister thinks that presents a problem and how this would interfere with the independence of the application of that prosecutorial policy.
Minister.
It is for the Lord Advocate to decide whether guidance and guidelines should or should not be published. That is part of his independence. In making that decision, I understand that he considers whether the publication of such guidance would be liable to prejudice the prevention or the detection of crime. There must be a... Certainly.
Vermindale.
I would just be specifically interested in what she feels, or where, sorry, the Minister feels the Lord Advocate wouldn't be able to do that here, and why she feels that he wouldn't be able to draft guidance that met that test.
Minister.
So, let me be absolutely clear. It is up to the Lord Advocate to decide, but there must be a risk that the publication of guidance, which is intended to inform decision-making by police and prosecutors, could be used as a guide to how to avoid prosecution or understood in a way which would tend to undermine the clarity which the bill seeks to provide. And it is best to leave the judgment in that regard to the Lord Advocate. Placing statutory obligations in this bill on the Lord Advocate in relation to the preparation and publication of guidance could set an unwelcome precedent for other areas. I would be also concerned about some of the consequences of the member's amendment. Instead of the bill itself just stating the commencement date 1 year after royal assent, the main provisions would come into force on the later of 1 year after royal assent or when the Lord Advocate's guidance is published. It wouldn't be appropriate to have these provisions brought into force without a clear date being stated on the face of the bill or in commencement regulation. That would create needless uncertainty and make it harder for the public to find out whether the law is actually in force or not. And I am absolutely sure that that is not the member's intention. Presiding Officer, Stage 3 should be about solving any technical issues in bills, not creating new ones. In conclusion, given the need to protect the independence of the Lord Advocate in this area, the undertakings already provided by the Lord Advocate in relation to his intention to issue guidelines to the police, and the uncertainties that the amendment might create, I ask Parliament to reject this amendment.
Thank you, Minister. And I call on John Finney.
Very much indeed, Presiding Officer. Can I first of all thank my friend and colleague Dick Lyle for coming to discuss the amendment with me in advance. Mr Lyle and I had a lengthy discussion, and I understand what motivates him to bring it forward, and I share the concerns of the circumstances that him and his family had to suffer. I have to say, and as I did say at the time, that I don't think this his amendment's going to help. He did talk about common ground. Of course, there's a lot of common ground. And I want to touch on some of the consensus about this, because I would hope to allay some of his concerns. I'm afraid there's some geeky technical stuff in here, so I'm going to be reading it, but I wanted to say that I do understand where he's coming from. This amendment would make the commencement of Section 1 conditional on the issuing of prosecutorial guidance. However, it could also give rise to uncertainty as to whether, on a particular date, Section 1 is in force or not. For a person to determine whether Section 1 was in force or not, they would need to ascertain not just whether guidance had been published by the Lord Advocate, but also whether the guidance had fulfilled the requirements of the amendment. This could well be disputed, and the amendment provides no means for that dispute to be resolved. So there would be no objective means for anyone to know whether the Section 1 was in force or not. The amendment also contains an inherent contradiction between issuing guidance on policy, which must be in general terms, while at the same time ensuring that it is appropriate to the, quote, individual circumstances of a particular case. The Lord Advocate cannot say what would be appropriate in every conceivable set of circumstances. Now, what we do know, and I would hope Mr Lyle would take some reassurance from, at stage 2, the lead committee heard from the Lord Advocate that the guidance will be prepared and issued to the Chief Constable. And I'll read what he said. If the bill is passed, I intend to issue Lord Advocate's guidelines to the Chief Constable of Police Scotland on the investigation and reporting of allegations of assault by parents on children. Those guidelines and prosecutorial policy will support, a very important phrase, because it's a phrase that Mr Lyle used, a proportionate and appropriate response, proportionate and appropriate, to the individual circumstances of particular cases. He went on to say, we're already in discussion with Police Scotland about the shape and parameters of guidelines. This is under active consideration. I certainly intend to issue guidelines as near as possible to the coming into force of the legislation. I issue guidelines to the Chief Constable, and it is then his responsibility to disseminate the instructions to his officers on the ground. I think very importantly, the Lord Advocate also set out details of the current policy available, the publicly available prosecution code, which contains comment on the public interest test and how the best interests of a child are central to decision-making. Now, we heard that in relation to contributions from both Police Scotland and social workers who are at the front line of dealing with these issues. So the amendment therefore seems to be likely to cause confusion as to whether Section 1 was in force or not, and add no value to the work that the Lord Advocate has already confirmed is underway. I hope that provides some assurance to Mr Lyle, but were he to press his amendment, I would ask colleagues not to support it. Thank you very much.
Thank you, Mr Finney. And I call on Richard Lyle to conclude and to press or withdraw his amendment.
Today, during a school visit by Taylor High School, I was asked what I believed in. I believe in the rule of law. I believe I should stand up and share my concerns at each and every opportunity, and I should listen to most of the time, to my constituents who have emailed me sharing their concerns re this bill. And I believe I should be allowed to share those concerns, and can I thank every member in this chamber for listening to me and listening to my concerns for a change without a single interruption. And I also thank John Finney for the discussion that we had. And, you put in amendments, and sometimes later on you have a thought and a change and whatever. So, in regards to the Minister's comments, checking back, I believe that the Lord Advocate has now indicated and has indicated he will begin discussions with Police Scotland, views producing procedural guidance. And as a feature of our law, the police are not obliged to report every crime. They report within the parameters that he lays down, and prosecutors are not obliged to prosecute every crime. So, due to these assurances, I will not now press my amendment, as I believe I have made the point for safeguarding, and that I have made the point that, as far as I'm concerned, assurances have to be, so I'm not pressing the amendment. Presiding Officer.
Thank you, Mr Lyle, but I'm afraid at this stage you're going to have to seek permission to withdraw the amendment. Does any member object to the amendment being withdrawn? Yes. It does. So the amendment will be put to a vote. So the question is that Amendment 1 be agreed to. Are we all agreed? Yes. We're not agreed. We'll move to a division. Members may cast their votes now. This is a 1-minute division. The result of the vote on amendment number 1 in the name of Richard Lyle is yes 47, no 63. There were no abstentions. The amendment is therefore not agreed. Now that brings us to the end of consideration of amendments. I'm sorry to say to members that the debate in the amendment stage has gone 25 minutes over schedule, and I don't particularly want you to curtail the debate on this bill, so I'm minded to take a motion without notice to move decision time to 5:25. If Mr Day would be willing to move such a motion. Thank you very much. So the question is that we move decision time to, no, it's 5:25, okay, to 5:25. Are we all agreed? Yes. We are agreed. Thank you very much. Now, as members will also be aware, at this point in proceedings, I'm required under standing orders to decide whether or not, in my view, any provision of the bill relates to a protected subject matter. That is, whether it modifies the electoral system or franchise for Scottish parliamentary elections. In the case of this bill, in my view, no provision of the Children Equal Protection from Assault Scotland Bill does so. Therefore, the bill does not require a supermajority at stage 3. So we're going to move on now to a debate on motion 18623 in the name of John Finney on the Children Equal Protection from Assault Scotland Bill. I would encourage all members who wish to speak in this debate to press their buttons, and I call on John Finney to speak to and move the motion in his name.
Thank you very much. And indeed, Presiding Officer, I'm delighted to be opening today's debate on whether the Parliament passes my member's bill, the Children Equal Protection from Assault Scotland Bill. It's been a privilege to lead the work of many dedicated organisations and individuals, both within and out with Parliament, without whom this bill would not have been possible. I'd like to thank, and in advance it's a lengthy list, I'd like to thank the convener and members of the Equality and Human Rights Committee for their diligent and measured consideration of my bill, displayed throughout the evidence sessions and at stage 2 of the bill. Special thanks also due to the clerking team and the Equality and Human Rights Committee. Thanks also to the many colleagues from all parties in the Parliament for their support and advice as my bill has progressed, and for the tremendous assistance from those outside Parliament, to Bernardo Scotland, NSPCC, Children First and the Children and Young People's Commissioner's Office. I'm also grateful to the Scottish Government and their officials for their support of my bill, and to the Children's Minister for Marie Todd for her active and informed support. I'd also like to thank Nick Hawthorne of the Parliament's Non-Governmental Bill Unit and Katrina McCallum from the Office of Solicitor to the Scottish Parliament for their tireless work. Excuse me. Finally, huge thanks also to Stephen Dane, my tireless office manager, long-suffering, for leading the work in my office on this bill. Last week, the leaders, an interim leader of all the Parliament's parties, received a letter from the President of the Faculty of Public Health, Professor Maggie Ray. The letter was co-signed by, amongst others, representatives of the BMA Public Health Medicine Committee, the Royal College of General Practitioners in Scotland, the Royal College of Physicians and Surgeons of Glasgow and its Edinburgh counterpart, the Royal College of Psychiatrists in Scotland and the Royal College of Paediatrics and Child Health. The letter urged the party leaders to show their commitment to supporting the health and well-being of Scotland's children, specifically stating, and I quote, We want a Scotland where all children can thrive. We want to support and empower families to give their children the best start in life. We want to deliver this bill to stop the long-lasting consequences of violence against children in Scotland. Presiding Officer, this is exactly why this bill was proposed to Parliament. For decades now, we've become increasingly aware of the long-term effects of physical punishment on children. The research is irrefutable. Professor Sir Michael Marmot of University College London, in the foreword to the report Equally Protected, published in 2015, stated, and I quote here, "The international evidence could not be any clearer. Physical punishment has the potential to damage children and carries the risk of escalation into physical abuse. It is now time for action." He went on to say, on the issue of physical punishment, Scotland is out of step with Europe and increasingly the world. There's an urgent need for Scotland and the rest of the UK to comply with international human rights law and to prohibit all forms of physical punishment. Dr. Anya Hellman, one of the lead authors of the Equally Protected report, told the Equalities and Human Rights Committee during Stage 1 evidence, I quote, "Our report on the evidence on physical punishment shows very clearly that such punishment has the potential to harm children, that it is not effective as a parenting strategy because it tends to increase problem behaviour and children's socio-emotional difficulties." The committee heard plentiful evidence on the physical and emotional effects of the current permissive law on Scotland's children as they experience it. I would like to take some time to discuss the wider effects of the current law in Scotland. What does the law, as it stands, teach the youngest members of our society? Surely the answer is might is right. Imposing one's will on a child through the use of force teaches that its legitimate means of mandating a desired behaviour. When rational argument will not do, physical imposition of power legitimately prevails. Presiding Officer, it's difficult to see how the aims of Equally Safe, the strategy to prevent violence against women and girls, which I'm sure every member in the Chamber supports, can be achieved while there is a contradictory legal approach which says, on the one hand, there's a zero-tolerance approach to violence in the home, yet an assault on a child may be subject to the legal defence of justifiability. Excuse me. Critics of this simple reform have often accused the bill of criminalising parents. There is no evidence that a change to the law results in increased prosecutions in any of the more than 50 countries where similar reforms have taken place. In fact, this change in the law in Ireland prompted more parents to contact services to ask for help and support with alternative disciplining techniques. Presiding Officer, surely this is something which should be welcome, an encouraging consequence of a positive legal change. In Scotland, we have many support services, both from within the government and in the third sectors, who, anticipating a similar reaction in Scotland to that in Ireland, where the bill to pass tonight, are ready to help parents, from services such as Ready Steady Baby, Ready Steady Toddler, our health visitors and parent clubs to Parent Line, Child Line and the One Parent Families Scotland Helpline. I'm grateful to all those involved in those ongoing preparations, the fruits of which will be harvested should members pass the bill this evening. It's very nearly 30 years, November 20th is the 30th anniversary since the UN Convention on the Rights of the Child was signed. Since then, states across the world have become required to protect children from all forms of violence. The UK has been repeatedly criticised for failing to take sufficient steps to comply with the requirements of UNCRC. My bill aims to bring Scotland into line with what appears to be the coming international standard in 57 countries, from the very first country in the world, Sweden in 1979, to Ireland in 2015, Nepal in 2018. The UK is now one of the very few European countries with no such protections. So I'm delighted that in Wales, Julie Morgan, AM, Deputy Minister of Health, who I had the great pleasure of meeting recently, is leading a bill following a long-standing campaign to give children equal protection. And that was supported at stage 1 by Welsh Labour, Liberal Democrat, Conservative and Plaid Cymru AMs. Since we had stage 1 debate of the bill, more countries have given legal effect to protect children from all forms of violence. And I hope this evening that Scotland can join South Africa, France in the Republic of Kosovo. In doing so, I move the Parliament agrees the Children Equal Protection from Assault Scotland Bill be passed. Thank you.
Thank you, Mr Finney. And just before we proceed, as members will be aware, the presiding officer is required under standing orders to decide whether or not, in his view, any provision of the bill relates to a protected subject matter. That is, whether it modifies the electoral system and franchise for Scottish Parliament elections. In the case of this bill, in his view, no provision of the Children Equal Protection from Assault Scotland Bill relates to a protected subject matter. Therefore, the bill does not require a supermajority to be passed at stage 3. So we will move on, and I now call on Marie Todd for up to 6 minutes, please, Minister.
Presiding Officer, I'm delighted to be speaking today for the Scottish Government. I want to begin by thanking John Finney and his team for all of their efforts in progressing this bill. And I want to say to Mr Finney, who I know is planning to retire at the end of this term of Parliament, that the Scottish Government is absolutely committed to upholding and promoting the legacy he leaves in the Scottish legislative landscape in the form of this bill. I want to thank children's charities for their support of the bill and for the valuable insights they've provided during the parliamentary process. And I'd like to pay tribute to Gillian Van Turnout, who I know is here today. Ireland led the way in these islands in removing this defence, showing us how simple it was to equally protect children. This bill is supported by a wide range of bodies and individuals. The Faculty of Public Health, other health bodies and bodies working for children jointly signed a letter on the 23rd of September urging this Parliament to support the bill today. There's support from many other bodies as well, including women's organisations and family law academics. The breadth of support for this bill clearly shows the importance of this bill. As the Minister for Children and Young People, I am committed to making Scotland the best place in the world for children to grow up. And that means placing children's rights at the heart of what we do, so that we create a Scotland where children feel loved, safe and respected. The removal of the defence of reasonable chastisement will help ensure that this goal can be achieved. And this bill places Scotland in the vanguard of providing children with the same legal protection from assault within the UK. That's the kind of country I want my children to grow up in. The Scottish Government supports the removal of this defence. The very name, reasonable chastisement, is outdated and unconscionable. It suggests that it's sometimes acceptable to hit a child. That's at odds with the Scottish Government's aim of helping children to grow up feeling safe. It's also at odds with the international evidence which shows that physical punishment of children is both harmful and ineffective. In line with international evidence, many countries have already changed their laws in ways appropriate to their own legal systems in this area. By removing the reasonable chastisement defence, we'll be providing children with the same legal protection from assault as adults. Why wouldn't we want this for our children? We'll also be ensuring that Scotland's approach is consistent with international treaties, best practices and human rights, and with the UN Convention on the Rights of the Child. As drafted, Section 2 of the bill provides that the Scottish ministers must take such steps as they consider appropriate to promote public awareness and understanding about the effect of Section 1. Should this bill be enacted, we'll take forward this obligation, as well as considering what else might be needed for implementation. We acknowledge the importance of raising public awareness of the effect of the removal of the defence. That's why we formed an implementation group, which has already begun to consider what might be required to implement this bill, should it be enacted, including awareness raising amongst parents, children and organisations, and resources. We will also, in line with the lead committee's comments at stage 1, consider how we can effectively raise awareness in hard-to-reach communities and minority groups. When working with the third sector, through universal and targeted support we provide to families and through the resources we make available, we promote positive parenting. We already have trusted channels of communication like the Parent Club website through which we can raise awareness about the bill and continue to promote positive parenting and provide practical tips and support for parents. As a parent myself, I understand only too well the unique challenges of parenting, and I understand the value of having access to practical support in those high-stress moments. So when we fulfil our obligation to raise awareness about the effect of this bill, we're not going to scold or cajole. As Liam Kerr said at stage 2, our goal should be to help parents to provide the best environment for their children. The Scottish Government wholeheartedly endorses that goal. Finally, I want to talk about clarity. Throughout this bill's progress through Parliament, we have heard many times that this bill is going to bring much needed clarity to the law. This bill will make it absolutely clear that physical punishment of children is not acceptable. This clarity will help parents, carers and beyond. There will be certainty about what the law is.
The Minister's just closing.
Parents will know what the position is, and frontline workers who support parents will finally be able to provide clear and qualified advice in this area. In conclusion, Presiding Officer, I hope that we will vote today to remove this antiquated defence of reasonable chastisement from the law of Scotland. I commend this bill to Parliament.
I call Oliver Mundell for 5 minutes, please.
Thank you, Presiding Officer. As I stated during the Stage 1 debate and during Stage 2 considerations of the bill, I believe violence against children is wrong. However, that's not the issue that's before us today. Today we're being asked to pass into primary legislation that is imprecise and suboptimal. It's presented by those who support the bill that the bill before us today is the only option. In fact, we could have passed primary legislation that up front at the start said physical punishment of children is wrong. That's what some of the other countries that have been mentioned did. I think we could have made a very clear statement on that if that's what this Parliament had wanted to do. Instead, we've decided to do half a job, and in doing so, I think we misdirect our focus, and we pass legislation that could unnecessarily criminalise good parents and draw others needlessly into the criminal justice system, certainly.
Alex Cole-Hamilton.
Very grateful to the member for giving way. Can I ask the member, if we had brought a bill to Parliament which up front said we will end physical punishment of children, would he have supported it?
Oliver Mundell.
I personally would have supported it, yes. I think the physical punishment of children, for me, I think if with the right thresholds and safeguards, should be considered. And I've said that today in an interview. But I do also respect the right of parents to make some of those choices for themselves. And that's why I think the threshold for state intervention is very, very important. And it should be set high for criminal intervention. It shouldn't just be a case that any physical punishment is instantly prosecuted. And that's what we're asking for here. And we're relying entirely on prosecutorial guidance to save parents from that intervention by the state. And I don't think that it is foreseeable at all for parents what circumstances they could find themselves entangled with the criminal justice system. I think one person's idea of what's the mild tap on the hand or a tap on their backside and someone else's could be quite different, and we're only going to have that discussion at the end of the process. When we've passed other legislation to change the common law, when we've introduced new offences, we've set out in detail where we think the law should start and end. In this case, we leave things very widely open, and I still haven't had a satisfactory answer, certainly.
Philip McGregor.
I thank the member for taking that intervention. I just wondered what weight the member puts on the evidence we heard in committee, because as other members have said, we heard loads of evidence from lots of different organisations saying that those concerns that you're outlining will not come to fruition. So what weight do you put and those countless number of agencies that came and spoke to us.
Oliver Mundell.
I thank the member for that intervention, and I say this as gently as I can. I sat in this Parliament very recently through the consideration of the named persons legislation, where the Deputy First Minister who sat here said to me he was confident that we could come up with a draft legal code. We then find out down the line that's not possible. I respect the views of organisations and I respect the principle that they're fighting for, but we could have had a much more robust piece of legislation before us that was far less narrow in its intent. The member who's bringing forward the bill wasn't able to give me a clear answer earlier on whether or not the rules of law that this bill seeks to change, whether or not they just apply to physical punishment or whether their scope is potentially broader. The Minister has not been able to say for certain, in response to my point and that from Daniel Johnston, where the start and end of our intention for behaviour that should be seen as criminal is. We're asking the Lord Advocate to decide on individual cases where things should be prosecuted and where they shouldn't. We should be taking responsibility, our responsibility as parliamentarians, to set out clearly in primary legislation where we think people should and should not be caught within the gambit of the criminal law. I don't think that this bill is acceptable, and I would refer members again to the article from Professor Tickell, because I think it does capture the point. I think too often in this Parliament we like to make bold and grand statements about what our views are. We want to, in this case, pass moral judgment on the behaviour of others and place that behaviour firmly within the criminal law. We can say we don't want to criminalise parents, but this law, as the Lord Advocate, as multiple legal figures have said, changes behaviour that is currently not criminal into a category of behaviour that is criminal. Yep. So therefore, it does open up the possibility of prosecutions, certainly.
No, I'm afraid you're just coming to an end. In fact, you have come to an end, Mr Mundell. Thank you. And before we move on further, can I remind all members that they should always speak through the chair, even when it's interventions. Please don't have conversations with each other, because I'm still here. And I've got toothache, and I'm in a bad mood. So there we go. And we now move on to Mary Fee for 5 minutes, please.
Thank you, Presiding Officer. I don't know if I want to speak now, given what you've just said about being in a bad mood and having toothache. Can I say at the outset of my contribution that I would like to thank John Finney for bringing forward this Members' Bill and for all the work that he has done on this issue. And can I also commit my support to this piece of legislation, which has been there since John Finney first introduced it, and also my party's support for this piece of legislation. And by passing this legislation today, Scotland will commit to protecting children from physical punishment. And that is an important step forward for children's rights. And as I said in the Stage 1 debate, and I would like to emphasise again today, this Parliament is a guarantor of human rights. And we, and every single one of us, has an obligation to protect the human rights of children. And the bill will help Scotland to meet part of its international human rights obligations under the United Nations Conventions on the Rights of the Child. And Labour is fully committed to the incorporation of the United Nations Convention of the Rights of the Child into Scots law. And this bill is a step towards progressing that commitment. And the bill seeks to give equal protection from assault by prohibiting physical punishment of children by parents or by caregivers. And let me be clear, this bill is not about criminalising parents and carers. It's about giving children the same protection in the law that adults currently have. Any kind of assault is assault. It cannot be justified by saying it was reasonable to hit that person. If a person strikes another person, they are assaulting them. Evidence that we heard in committee demonstrated that physical punishment is harmful to children and is likely to lead to an increase in negative outcomes. Parents, children and family support services are best served by adopting methods that do not involve physical punishment. And this bill has often... Yes, certainly.
Liam Kerr.
But how does the member respond to Adam Tompkins' point from earlier that the category assault is not necessarily limited to simply physical assault?
Mary Fee.
The member makes a point. Assault is assault. If we assault someone, we are committing a crime. There are varying ranges of assault. We should not use force to control another individual. And that force could take many forms. The bill has often been described incorrectly as a smacking ban, but it's important to remember that this bill doesn't create a new criminal offence. Rather, it seeks to remove a legal defence to give children and adults the same legal protection from assault. This is a bill about equality and about respect for children's rights. And it gives the same rights and the same protections to children that we as adults have and enjoy. And I do understand the concerns that were raised by parents who argued that the bill could lead to an increase in criminalisation for parents. The bill does not make changes to policing or prosecution procedures or practice. Police Scotland said it would continue to take a view as to whether there was enough evidence to charge a person, and the prosecution authorities would decide whether there was sufficient evidence to support a case. Indeed, international experience from countries that have already addressed the use of physical punishment suggests that prosecutions would not notably increase following the passing of this legislation. Ireland unanimously repealed its common law defence of reasonable chastisement in 2015. And Gillian Van Turnhout, the former Irish senator who introduced the amendment that led to the prohibition of corporal punishment in Ireland, said that since the implementation of the law, Ireland had not seen a dramatic increase in prosecution of parents. And a key factor in the bill is its aim to facilitate a cultural change that will protect children from violence. And the public education strategy will seek to work in the same way as the ban on smoking in public places and legislation requiring the use of seatbelts, not to criminalise, but to encourage positive change. And the importance of this campaign, sorry, I'm almost finished, I do apologise. The importance of this campaign cannot be overemphasised. There needs to be a coordinated campaign message so that parents, caregivers, teachers and social workers are aware of the implications of the changes being made. And I do hope that this legislation will be backed with sufficient funds to raise public awareness for that change. Indeed, I hope that in giving equal protection from assault, we can focus on properly resourcing and supporting children that have experienced abuse. This bill does not give additional funding to help children and families where abuse occurs. And I sincerely hope that this can now be our focus so that every child can grow up in a safe and loving environment. And I would urge all of Parliament to vote in favour of this legislation at decision time tonight.
I call Alison Johnson for 4 minutes, please.
Thank you, Presiding Officer. The law, as it stands, affords children less protection from physical assault than we adults benefit from. And that is quite simply wrong. My colleague John Finney seeks Parliament's support to change this today, to give equal protection to our youngest citizens. And I'm particularly proud to speak in support of my Green MSP colleague. I feel so strongly about the importance of this legislation that if Mr Finney had not taken it up, I would have sought to do so. Who could possibly disagree with Barnardo's Scotland when they say that we want to see a society and a culture where no violence against children is acceptable? This bill is it's part of an important change in our culture, to one that champions non-violent ways of encouraging learning and behaviour change, and this change is long overdue. Article 19 of the United Nations Convention on the Rights of the Child tells us that children have the right to be protected from being hurt or badly treated, and our current justifiable assault defence contravenes children's rights, and today we can change that. I want to live in a country where all children and young people know and understand their rights. I want our young people to know that these rights aren't just words alone, that they actually matter, that they can be realised. Human rights aren't a matter of opinion. This Parliament, and Mary Fee focused on this, this Parliament prides itself on Scotland's respect for human rights. But for every one of the 20 years that this Parliament has existed, Scotland has been in breach of the UNCRC. Again, Article 19 is absolutely clear. It says, and I quote, "States parties shall take all appropriate legislative measures to protect the child from all forms of physical or mental violence." Yet the existing loophole in our law says that sometimes it's okay to use violence when disciplining our children. It is not, and we have been told that it is not repeatedly. In 2002, the UN Committee on the Rights of the Child said that continuing to allow physical punishment was a serious violation of the dignity of the child, and that it undermines educational measures to promote positive and non-violent discipline. No wonder then that the bill is supported by Police Scotland, by Social Work Scotland, by Children First, by the Royal College of Paediatrics and Child Health, by the NSPCC, Bernardo's, by the Children and Young People's Commissioner for Scotland, to name just a few. It is strongly supported by young people themselves. A pupil at school within my region wrote to me in support of the bill, as many did. On physical punishment, they said it hurts and could leave a mark or physically damage the child. Also, that it is very sore. They went on to say that people who are hit themselves think it's okay to hit each other, and no person would like that, would they? Before closing, I'd like to pay tribute to John Finney and his team. I know from my own experience promoting a Members' Bill, particularly on a topic which attracts such public and media attention, it's a significant piece of work for the MSP and their staff, and John and his tireless office manager, Stephen Dane, have worked very hard to get the bill to this stage. And I'd like to thank everyone too who has worked with them. John, as we've heard, will step down from Parliament at the end of this session after a decade as an MSP, many more years as a police officer, and he's been a councillor too. And if the bill passes this evening, it will stand as testament to someone who has spent their career serving others and seeking to improve lives. Presiding Officer, we can't allow the defence of justifiable assault to remain in our laws. If we are to create a Scotland which is truly the best place in the world, not only to grow up, but to flourish, we can't implicitly endorse the use of violence against children. Colleagues, we can change this today by voting for equal protection from assault for children. Thank you.
Call Alex Cole-Hamilton for 4 minutes, please.
Thank you, Presiding Officer. Can I start by welcoming to the gallery Gillian Van Turnhout, so many dear friends and colleagues of the children's sector who I used to work with. But most importantly, can I welcome the many children in our gallery today? This bill is for them and those that follow them. Presiding Officer, this is a proud and emotional day for me. Today, a road I have walked for 20 years finally comes to an end. On that journey, I have stood shoulder to shoulder with some of the finest people I know, and I want to thank them each personally for their efforts that have spanned nearly a quarter of a century to bring about the act that we shall pass this evening. 3 children's commissioners, a former Irish senator, and so many advocates within the children's sector. Each of them has played their part in this, and together they represent the vanguard of children's rights in our society. They will each be remembered for the change that they have achieved today. Together we have worked to support the architect of this bill. As a former police officer and repentant parent who used to smack his children, John Finney has lent wisdom, experience and understanding of the journey that so many Scottish parents have been on in recognising the harm caused by physical punishment. Thank you, John. This is not a big law. It's not even a big change. It simply removes an antiquated legal defence of justifiable assault on the grounds of reasonable punishment. Presiding Officer, this is a legal defence that used to allow men to hit their wives and servants. That defence was removed long ago, and we would not dream of allowing it to be reinstated. As such, the case of its repeal in respect of children is unanswerable. Those who have to deal with assault and abuse both in our streets and in our homes made powerful representations to our committee. They told us that we shall forever fail in our efforts to end such brutality for as long as the state sanctions any kind of violence in the home. We have heard many arguments for the retention of physical punishment and this defence, but none have withstood the test of our committee's scrutiny or the evidence offered by the bill's supporters. Smacking is not an article of faith. It is not demanded by Scripture. It does nothing to prevent children scolding themselves or running into traffic. Parents do not use its application consistently or always retain control when they do. And a light tap on the wrist or the bottom is not the full extent of every parent's intervention. That last point matters because, Presiding Officer, the only clarity offered in Scots law around physical punishment came by amendment in 2003. The sum total of statutory direction on this matter is no headshots, no use of implements, and no shaking. That's it. On everything else, our law is silent. But above all this lies the fundamental disparity of treatment between adults and children that this arcane defence creates. We would not for a minute consider relaxing the law around assault to allow the physical punishment of an adult with the mental age of 3 as a tool of correction or of protection. So why do we permit it for actual 3-year-olds? To maintain this defence is to argue, I don't have time, to maintain this defence is to argue that it's only okay to assault someone in our society if they're smaller than you, if they haven't reached adulthood yet, and if they cannot hit you back. That is not compatible with our aims to be thought of as a human rights leader. It's not even compatible with our aims to be thought of as a civilised society. Today, Presiding Officer, Scotland joins a family of more enlightened nations, those countries who have recognised that the measure of a modern and progressive nation is in the rights it extends to its most vulnerable citizens and in the protection it offers its children. I will take great pride in voting for it tonight.
Now move to the open debate, and we're really pushed for time, so strict up to 4 minutes, please. Ruth Maguire, followed by Gordon Lyndhurst.
Presiding Officer, this bill is about rights. Children have the right to protection from all forms of harm and physical violence. Children have the right to grow up in safe, nurturing environments which are free from violence. When anyone's human rights are denied, everyone's rights are undermined. And as things stand, without equal protection from assault, children's rights are not being realised. Because of their physical and mental immaturity, children are entitled to and require more, not less protection. The current legal position in Scotland must change. This bill, which I will be very proud to vote for this evening, is a simple one. By removing the defence of reasonable chastisement, it gives our children in Scotland the same protection from assault as adults. I take very seriously my party's aims to make Scotland the best place to grow up and our commitment to incorporating the UN Declaration on the Rights of the Child into Scots law. Removing the defence of reasonable chastisement is consistent with this aim and commitment to human rights and international treaties. Most witnesses to our Equality and Human Rights Committee supported the idea that the realising of children's rights could not be fully achieved without taking legislative steps to remove the defence of reasonable chastisement. Scottish Child Law Centre stated that if Scotland is to meet its international standards of human rights and child's rights and to achieve its aim to be a nation which promotes the best possible start for children in life, then it's of crucial importance that any legal defence or justification for acts of violence against children are removed. I've done a lot of listening through the passage of this bill, and I'm just going to share my thoughts for 3 minutes, if that's okay. Internationally, the use of physical punishment is increasingly regarded as unacceptable. Presiding Officer, I acknowledge the difficulty and the discomfort that this debate, that this proposition causes some people. Many of us grew up in very different times. Some of us may well have been scalped or smacked growing up. And yes, some of us might even have turned out all right. But taking action to improve things for children now and in the future is not a judgment on our parents or their parents or parents now who are doing their very best. But the inescapable fact is, we know better now. Evidence shows physical punishment can cause long-term harm to children. It's associated with increased childhood aggression and antisocial behaviour, can be related to depressive symptoms and anxiety among children, and carries a serious risk of escalation into abuse. All things which not only impact a child at the time, but also can cause problems in later life. And even if it doesn't always, if it can cause harm, why on earth would we take the risk? In closing, Presiding Officer, I wish to personally thank my colleagues, all members of the Equalities and Human Rights Committee, the ones who agree with me and the ones who don't, the parliamentary staff who so ably and diligently supported us, and all the many folk who shared their views, their opinions, their worries and their aspirations. If I may give a special mention to the children and young people in Portree High School and Boonscoll Gaelic First 3, Morantang, Vashif Jirach Scunyo, I aspire to a Scotland that is the best place in the world to grow up, a Scotland that protects and promotes human rights. So finally, can I just thank John Finney for bringing this bill and taking us a step closer to that place.
Gordon Lyndhurst, followed by Daniel Johnson.
Presiding Officer, John Buchan, the Scottish politician, lawyer and novelist, in Memory Hold the Door, recorded some of his personal recollections of people he had known, such as Lord Milner, who he described as being the last man suitable for a particular task. And I quote Buchan, "He detested lies, and diplomacy demands something less than the plain truth." One wonders what Lord Milner would have thought of current British politics. And Buchan continues, how often he would study a scheme of mine with knitted brows and lay it down with a smile. Very pretty, but it won't work. Apt words, perhaps, for the bill before us today, which has the word equal in its title, as if that made anything right. For the bill does no such thing. Rather, its effect is to enable increased state interference and destabilization in family life, to the detriment of children and criminalization of ordinary parents. Good intentions here or there, the actual effect is to open the road to prison for unsuspecting parents. I'm afraid that I have very little time to speak like others, so I can't take an intervention. I don't wish to aggravate the presiding officer's toothache further. If I might move on, supporters of the bill have always said that the purpose of the bill was not to criminalize parents or increase prosecutions, but rather to bring us into line with other countries. But the bill does none of these things. That is why I presented amendments at stage 2, all of which were, in private, decided by the drafting clerks to be inadmissible. Even an amendment which ensured the non-criminalisation intention, and an alternative requiring prosecutions within 2 years of any alleged offence. The types of protection guaranteed in almost all countries supporters of the bill rely upon. But Ruth Maguire, as committee convener at stage 2, and the presiding officer at stage 3 have prevented those amendments coming forward to Parliament. And apparently, we MSPs don't even deserve to be told the reasons for their decisions. Now, if there had been proper scrutiny of the bill, if proper consultation, by which I mean the voices of ordinary people who contributed and experts, note, who disagreed with the bill, actually being listened to, if MSPs had been allowed to bring forward appropriate amendments, we might have been looking at a different bill today which had wider and much more support. But we are not. It is as if none of the intermediate stages from the bill proposal at the start had ever happened at all. What we have seen in this bill procedure is a serious failing by this Parliament. It has been undemocratic, it has not been transparent, and it is quite frankly a disgrace. It is this sort of conduct by current politicians that destroys public confidence. It is not pretty at all, and it will not work.
Call Daniel Johnson to be followed by Fulton McGregor.
Thank you, Deputy Presiding Officer. I too would like to begin by thanking John Finney for his tireless work in bringing this bill to Parliament, because I do think it's important that this bill passes this evening, because the law as it stands neither makes sense, but most importantly, it does not reflect the realities of parenting and bringing up children in 2019. Because currently, assault is illegal unless one is reasonably chastising a child. This is flawed, if not absurd. Because how can it be right to allow a defence for assault based on the category of person who is being assaulted, let alone those who we should be seeking to protect and nurture, namely our children? There is, of course, a reasonable need to discipline a child. Any responsible parent knows this. But equally, how could discipline that requires causing pain to a child, that would otherwise be considered assault if it was inflicted on an adult, ever be considered reasonable? I do not think that it can, and therefore we need to remove this legal defence and provide equal protection to children from assault, as we do all other people in society. That's why I believe we should pass this bill at decision time. I will.
Liam Kerr.
I'm very grateful to Daniel Johnson for taking the intervention. The member knows my view on the premise that he's just outlined, but does he not accept that the bill should be absolutely unambiguous and clear in its scope?
Daniel Johnson.
I think in broad terms it is, but I do share some mild concerns, and I was going to come to this later on in the speech, because I do not think, as we debated the amendments, we necessarily covered ourselves in glory this afternoon, because I think there was a need for clarification in terms of the use of restraint. Now, in broad terms, I accept the points around intent and unreasonableness. I also accept that the courts and prosecutors, day in, day out, apply these sorts of tests. However, there are circumstances and examples, such as lifting a child out of the room, which if you were to have those exact same actions occur with an adult, I'm not sure I understand precisely the difference. And I appreciate John Finney's clarification around criminal intent, but to simply lift an adult out of the room to calm them down, I think perhaps, at the very least perhaps, could be considered criminal intent because you are frustrating the intentions of that individual. Now, I just believe that that clarification could have been. And more importantly, I think it's for Parliament to test the law that we are seeking to pass. And I have to say, with respect to the Minister, I think it's with concern that she met some of those calls for clarification with a scoff and didn't answer them at all. Because ultimately, it is our duty to test the law. It is our duty to ask for distinctions and clarifications. And therefore, I think it is right that we ask for those. And I think it's with regret that those were not met. But ultimately, I think it is important that we pass the bill this evening, in part because there's a fundamental belief on my part as a parent that parenting, you get what you reap what you sow. That in many ways that your behaviour is reflected by your children, and you don't calm a child down by shouting at them. You don't resolve bad behaviour by being unreasonable yourself, and you certainly don't teach a child that aggression is wrong by striking them. So for these simple reasons, I do believe that we should pass the bill. We do need to change the law, because I think fundamentally that physical discipline is counterproductive, but moreover, that society has changed, and so must our law. Thank you.
The last of the open debate contributions is from Fulton McGregor.
Thank you, Presiding Officer. When I stood up for the Stage 1 debate in this chamber a couple of months back, I said that it was a really simple bill for me to support, a no-brainer, and nothing has changed. I would like to start by, like others have done, thanking John Finney for his tireless work in this bill. And I'm very happy for him, as Alison Johnson mentioned. I know that I seen his announcement on social media over the summer recess that he intends to stand down, and what an achievement that would be if we passed this bill tonight, and credit to him. And I'm personally very happy for him in anticipation of his doing that. And I want to thank all the organisations also who have worked over many years to make it happen. Bernardo's, Children's First, NSPCC, Children's Commissioner, Amnesty International, and I'm sorry if I've missed any others who are in the gallery, but the many organisations who have fought for this and got it to this stage. And again, for them, I hope that every member votes to pass this bill tonight. As Gail Ross said earlier, Presiding Officer, in the amendments part of the debate, if we're thinking about what almost all stakeholders told us during the committee stage, and they almost all told us the same thing, as MSPs, we've got a responsibility in how we respond to our constituents and the wider public when concerns are raised. The evidence continually told us, I can't overemphasise that this bill will protect children's rights, it will bring equality and will not lead to the criminalisation of parents, as it doesn't change the current child protection processes that are already in place. It removes an outdated defence. It's our duty then to allay fears and concerns, and we're in the privileged position, particularly those of us who are members of the committee, to have heard the evidence and take that forward. And I'd like to give an example of that and pay true credit to my friend and colleague Richard Lyle, which we've seen democracy in action today, didn't we? An amendment was brought forward. He had a response from the Minister, from the member in charge, and he changed his mind. And that's what we should be doing with ministers. And I hear somebody laughing there, but that is what is happening. We've seen democracy in action. And some of the fears that have been expressed, they're not justified, Presiding Officer. We've said this before. And indeed, I would go as far to say that they're only there to scaremonger. You know, in the last debate, I mentioned my own social work experience, and I would apply that again. You know, when I was working in social work, you know, there was always a measured response from agencies, whether that be the criminal justice agencies or the care agencies. And that we heard from social work, we heard from the Procurator Fiscal and others that won't change. Again, I repeat, this is not creating a new law. It's removing an outdated defence. I can't believe that anybody would think that we shouldn't be doing that. A defence that we couldn't even get figures on how often it has been used during committee. Folk just didn't know. People weren't thinking about it. This bill will make the law and processes clearer. That's what we heard was one of the main benefits of the law, and that's why the Tory amendments couldn't be supported earlier. One of the most important things is that practitioners and parents have clarity around the law, because, as others have said, there is a lot there of people thinking, well, you know, is this not already illegal? And that sort of thing. It's about and some of the examples that were given, particularly by Oliver Mundell, about, you know, and I know Daniel Johnson put it in another way, and I was thinking about not saying this because he actually put it in probably a better way, but, you know, the analogies of picking up a child and confiscating a mobile phone. This is quite simply about equal protection. The clue's in the name of the bill, Presiding Officer, equal protection from assault. I'm asking the Tory benches to join us tonight in voting for it.
Now move to the closing speeches, and I call Ian Gray for up to 4 minutes, please.
Thank you, Presiding Officer. And as we come to the culmination of a great effort by John Finney in getting this bill to this very final stage, let me add my congratulations to him for having done so. It must have seemed like a long road for him, but for some of us it really stretches all the way back to the earliest years of this Parliament, when we considered similar legislation and on that occasion fell short of fully protecting our children, keeping the compromise of reasonable chastisement, which we will, I fully expect, do away with in a few minutes. I think we can believe that Parliament, and indeed society, has moved on since those days, because those of us who were around will remember what an angry, bitter and difficult debate that was then, in here and in the country. We spent time debating why it might be okay to hit a child with a slipper, but not a coat hanger, though thankfully, even then, we concluded that neither was reasonable. And if that seems barbarous, then remember that this was only a few years on from a time when teachers routinely hit 5-year-olds with a thick leather belt. Time moves on, thank goodness, and so too does this Parliament. So this bill has been, I think, a much more mature consideration of a basic principle that children should have the same protection from assault as adults do. There have been concerns around, of course, and perhaps that's why we have a Members' Bill before us this evening rather than a government one. But I think they have been reasonably and fairly explored. I disagree with Mr Lyndhurst's take on that. And one part of that maturity of this Parliament is our greater understanding of rights. And indeed, our desire to see our nation ever more shaped by those rights and respect for them. And a key aspect of that is the commitment mentioned by many speakers this evening and shared by the Labour benches that we wish to see the UN Convention of Children's Rights incorporated in our legislation. Now, the UNCRC says that states shall take all appropriate legislative, administrative, social and educational measures to protect the child from all forms of physical or mental violence. There is no ambiguity. Physical punishment breaches the Convention. So if we wish to claim to be a rights-respecting Parliament, we must pass this law this evening, and I think that we will. But, Presiding Officer, if we wish to claim that we truly respect the rights of children, this bill is a necessary but not a sufficient condition. Mr. Mundell warned us against a liking for bold and grand statements, and I think he's right. Because as long as 1 in 4 children live in poverty in our country, as long as a child born to a poor family is 3 times more likely to die young, as long as 70,000 children need emergency food parcels, or 36,000 children are referred to mental health services in a single year, then to claim to be the best country in the world to grow up in is a rather vainglorious boast. We will end reasonable chastisement tonight, I'm sure, as we should have done so 20 years ago. And let's celebrate that, and let's congratulate Mr. Finney. But while so many children still suffer unreasonable punishment just for the sin of being poor or vulnerable or sick or disabled, then we shouldn't pat ourselves on the back too hard.
I call Liz Smith for up to 5 minutes, please.
Thank you, Deputy Presiding Officer. I think it should go without saying that when this Parliament seeks to pass legislation, it should adhere to some key principles. The legislation should be clear and uncomplicated. It should be based on fairness and maximising the common good. It should be acceptable to the public, who must see the legislation as both useful and beneficial. And as far as possible, it should be easily enforceable and not be open to constant debates about repeal. The Scottish Conservatives have never taken issue with the good intentions of those promoting this bill. Indeed, there are some in my party who would have chosen to support it. But there are many of us in this chamber, not just on these benches, and indeed some who are absent today, who have grave reservations about what we have before us, because the bill does not meet the good legislation tests. As my colleague Adam Tompkins clearly set out during Stage 2 debate, the fundamental failing of the bill is the wrongful classification of reasonable chastisement as assault. And throughout Stage 2 and again throughout Stage 3, its proponents have not been able to address this fundamental failing. In fact, I actually find it rather disturbing the number of occasions throughout the passage of this bill where the very distinct definitions in law have not been wholly recognised. Now, Daniel Johnson and I will probably vote different ways this evening, but he makes a very important point about the need for clarity. And that clarity has not been forthcoming. Indeed, there are serious problems about the bill because it is weak and it has so many grey areas. It is still devoid of the conclusive evidence to prove that the legislation will make children safer. Indeed, the bill is severely weak in key areas about why the current law is not acceptable. Because we have worked through this. Mr. Gray mentioned that we have been at this debate several times in the past. I well remember the debates when David McCletchie and in fact, I think most of the leaders actually in the party at the same time, and Jim Wallace himself, made it very plain that some of the difficulties that the Parliament faced about this legislation were for exactly the same reasons that are put to us today. And it is about what makes for good legislation. Because at the time, one of the reasons why we didn't decide to abolish the reasonable chastisement defence was because we found that in law, it was going to create so many difficulties. And it's very clear from what has happened at stage 2 that we still have that problems. And my colleague Oliver Mundell has made very clear that there are issues for the Lord Advocate, as he will have to seek to produce the necessary guidance to accompany the legislation. That has not gone away. Now, my colleague Gordon Lyndhurst mentioned that there is a movement away from the responsibilities of parents into what the state feels is better for families. And that is something that I think is a fundamental problem with this legislation, and it is something that has been rejected time and time again by parents. We've seen that in recent instances as well. I won't, if you don't mind, Mr Cole-Hamilton. So when it comes down to the advice that we have been given by Police Scotland, the Law Society, the Scottish Children's Reporter, I fully acknowledge that they state that there is no intention to criminalise parents. I understand that. But what we have in this bill is exactly that, because of the way that it has been drafted. There is an increased likelihood that we will have a criminalisation of parents. It may not be many, but there is that risk. And that is why this bill has got so many faults. And it's something that Police Scotland and social workers have raised about the confusion that that can raise for parents, because they are unsure about exactly where they stand. And Deputy Presiding Officer, can I finish my remarks on exactly that point? This Parliament should always be judged about what we put forward as legislation. This legislation has so many faults that it is not acceptable, and therefore we will not be supporting it on this side of the House. Thank you.
Now call Marie Todd for up to 5 minutes, please, Minister.
I'm grateful to members who've contributed today to this debate, and I wish to comment on some of the points that have been raised. Daniel Johnson raised the issue of restraint. That was wholly considered in committee, and the Stage 1 report was very clear that restraint to safeguard a child is not affected by the bill. He also asked me a specific question. Is lifting an adult from one setting and moving them to another assault? Well, the reality is it would depend on the facts and the circumstances. It could be justified and thus not criminal if, for example, it was self-defence. That defence will be equally available in relation to adults and children after this bill as it is now, but it will depend on the facts of the case. As I said in my opening speech, the Scottish Government supports the removal of reasonable chastisement defence because it's in the best interests of children. Members opposite have raised concerns that removing the defence will criminalise loving parents. The evidence from other countries that have made similar changes suggests that this simply will not be the case. Neither Ireland nor New Zealand, where the change in the law was handled in a similar way to this bill, has reported a significant number of convictions following changes in the law there. And the lead committee heard from the Lord Advocate that he intends to issue Lord Advocate's guidelines to the Chief Constable of Police Scotland on the investigation and reporting of allegations of assaults by parents on children. Those guidelines and prosecutorial policy will support a proportionate and appropriate response to the individual circumstances of particular cases. The Scottish Government recognises the key role of parents and carers in our society and aims to provide them with support in the very challenging and yet vital job that they do. And as part of that, in line with Section 2 of the bill, we'll promote awareness and understanding of the removal of defence. We'll also continue to promote positive parenting and to provide support for families who need it. I think we've had enough interventions today, I'm afraid. I think I'll just make... Certainly.
Michelle Ballantyne.
In the financial memorandum that accompanies this bill, at section 30, it talks about the fact that you wrote to say that in terms of marketing and making parents aware of this bill, that you were only seeking to use £20,000 and do it through a website. And yet in previous campaigns, you have considered it necessary to spend a lot more. Do you really think that is adequate for a bill like this?
Remember to always speak through the chair, please. Marie Todd.
Absolutely. We'll provide people with practical advice and information using existing channels, such as Parent Club, that people already trust and rely on. But awareness raising isn't just about families. We also know that public bodies like Social Work Scotland need to be involved, along with third sector organisations. Our approach to awareness raising will involve consideration of the needs of professionals who provide support for families, like Social Work Scotland, and we'll work in partnership with the voluntary sector, children's organisations and others to raise awareness. There will be resource implications from raising awareness, but these will, of course, be driven by the form that awareness raising takes. Of course, we want awareness raising to take the most effective form possible. And that's just one of the reasons why we've set up an implementation group to consider what needs to be done should the bill be enacted. And that group met very recently, 23rd September in fact. And at that meeting, group members discussed awareness raising and monitoring the impact of the bill. The group will hold further meetings over the next year and will listen to the points raised about resources. The implementation group also includes bodies who deal with the implementation of criminal law, such as Police Scotland, the Crown Office and the Procurator Fiscal Service. It's been suggested here today that the law of assault is not clear and that the bill will create confusion rather than add clarity. I have to say bluntly that I do not agree with this. I will reiterate, as the Lord Advocate said about the law of assault, it is applied day and daily by police officers and prosecutors. There is not a problem with the clarity of the law. What the removal of the defence means is very clear. Parents and carers will no longer be able to use the reasonable chastisement defence. In conclusion, the Government supports removing the defence. I look forward to voting for the bill and to providing children with equal protection from assault.
I now call John Finney as Member in Charge to wind up this debate. You take us to decision time at 5:25, please.
Okay, thank you very much indeed, President Officer. And I'd like to thank members who have participated in the debate there. And I'm going to reflect on some of them. I'm sure members will understand in the wish to remain very positive. I'm not going to mention all the contributions. But the Minister, can I thank the Minister for our support? In fact, can I thank all members for their kind personal remarks? Can I thank the Minister for her supportive comments and talking about the long-term goals that the government has in the plans. And I'm aware of the implementation group and the work that's ongoing there. And I think her comments about the universal provision and the targeted support that is there is something that's very important. My colleague Mary Fee said, and I hope I noted her correctly, an important step forward for children's rights. And then highlighted the obligations placed on all of us regarding this Parliament's role as a guarantor of children's rights. My dear friend and colleague Alison Johnson, who I'm very grateful for support, not just in this issue, but many issues, also laid out some very interesting information, not least the contact you'd had from a young person and the concerns that the young person had said that will hopefully, are going to, at decision time, will be addressed. Mr Cole-Hamilton was one of the individuals who I was meaning to refer to. There's many, but his long-standing commitment to this cause is to be recognised and applauded, and I'm very grateful for his support, often throughout this process, and his comments about wives and servants, I think, and put this very much in context of how an anachronism this situation we find ourselves in. Ruth Maguire, children's rights are not being realised. Well, we've an opportunity to address that, and again thank her and her committee for all their hard work. Colleague Daniel Johnson used the term flawed and absurd, and I think that is absolutely correct. And he also used the terms about protection and nurturing, and I think that should be key to our deliberations. Fulton McGregor, and we're always grateful for his background in social work to understand when he talked about the measured response from agencies. And that won't change. Of course it won't change. We heard from the police and social work during stage 2, nothing's going to change. The morning meeting that considers the accusations that are made and the joint response that's going to take place will be exactly as it was before. Turning to Mr Gray, and I thought with Ian Gray there we had some longer-term reflections, and I thought it was very interesting. He said that the previous deliberations had fallen short of the outcome, and I think that's true, and that time moves on. And I think it's true to record, and certainly there'll be no rejoicing that the job's done here. Much of what he said about poverty and the problems that our children face are absolutely true. It's not being addressed by this very modest measures in the bill, but of course there is an opportunity to do this. In the relatively short time I have left, we would always call on the advice of the Children's Commissioner, and he's laid out to us a whole range of reasons why support should be given. The bill plays an important role to ensure comprehensive legal protection from violence for all children. All children have an equal human right to respect for their dignity and physical integrity. Assaulting a child for the purpose of punishment should never be lawful. Legalised violence against a child in one context risks a tolerance of violence against children generally. And as has been said by many, there's no such thing as a reasonable level of violence. And these standards have been set by the UN and the Council of Europe, and I think we want to aspire to meeting them. And we also, the Commissioner talks about the overwhelming expert evidence. And we heard from many people during the debate about our obligations, to protect children and recognise their particular vulnerabilities. Children are rights holders. I think that's something that I find quite unpleasant in some of the discussion, the idea that children don't have rights. It's absolutely the case that they have rights, and this is the place when these rights should be realised or guaranteed. This is a lawmaking building, Presiding Officer, and I was reflecting what we're here for. We're here to make things better for our nation. This legislation is not a critique on how our parents brought us up or how we brought our children up. It's not a challenge to people's rights to hold differing views. We're here to make laws. We're here to scrutinise. And of course, that is about the scrutiny of our international obligations. We're here to make good laws that reflect other aspirations regarding the lives that children lead in Scotland, to make good laws based on sound evidence, and the overwhelming evidence supports the bill. To make good laws based on sound evidence to make things better. And this legislation meets all those criteria. It protects and nurtures, and I hope, for Scotland's children's sake, you'll support it. Thank you.
Thank you very much. That concludes our debate on the Children Equal Protection from Assault Scotland Bill. The next item of business is consideration of Business Motion 19271 in the name of Graham Day on behalf of the Parliamentary Bureau, setting out revisions to next week's business. And can I call on Graham Day to move this motion?
Moved, Presiding Officer.
Thank you very much. And I would just draw attention to this means a late decision time next Wednesday for a stage 3. No member has asked to speak in the motion. The question is that motion 19271 be agreed. Are we all agreed? Yes. We are agreed. Thank you very much. So return to decision time. There's one question today. The question is that motion 18623 in the name of John Finney on the Children Equal Protection from Assault Scotland Bill at stage 3 be agreed. And members should cast their votes now. The result of the vote on motion 18623 in the name of John Finney is yes 84, no 29. There were no abstentions. The motion is agreed and the Children Equal Protection from Assault Scotland Bill is passed. Thank you, colleagues. That concludes decision time, and I close this meeting.